Donald Trump is gagged, and gagged now for good. The D.C. Circuit Court of Appeals has ruled that Judge Tanya Chutkan's gag order will remain mostly. There's a very small limitation or adjustment to her gag order, but Donald Trump is gagged. And we know he's gagged because he truthed right afterwards. That's what you call what he does on his social media account, that an appeals court has just largely upheld the gag order against me in the ridiculous J6 case, where the unselect January 6th committee deleted and destroyed almost all documents and evidence, saying that I can be barred from talking and, in effect, telling the truth. In other words, people can speak violently and viciously against me or attack me in any form, but I'm not allowed to respond in kind. What is becoming of our First Amendment? What is becoming of our country? We will appeal the decision, which means he's claiming he's going to go to the Supreme Court. But for now, he is gagged. So let's talk about, though, exactly what the order says. My co-host, Ben Meiselas, and I from Legal AF did a very short duet hot take talking about the fact that the gag order stays and what it means, but I dove into it a little bit more. And so let me talk just in detail about this decision. It's just a momentous decision. It's 68 pages. The three-judge panel is the same three-judge panel that heard oral arguments just last week. Judge Millett, who's an Obama appointee, Judge Pillard, also an Obama appointee, and Judge Garcia, who's a Biden appointee. And the decision said that essentially what's happening right now with a gag order in this particular case, in this criminal case, don't forget this is the January 6th federal Jack Smith bringing the case in Washington, D.C. in front of Judge Tanya Chutkan. And the D.C. Circuit said there's a confluence of two paramount constitutional interests. Number one, freedom of speech and the First Amendment. And number two, the federal court's vital Article III duty to ensure a fair and orderly administration of justice in criminal cases. And they said that they agree with the district court, meaning Judge Chutkan, that some aspects of Trump's public statements pose a significant and imminent threat to the fair and orderly adjudication of the ongoing criminal proceeding, warranting a speech-constraining protective order. However, the order sweeps in more than necessary, so it's affirmed in part and vacated in part. And so that language is taken just straight from the order, from the decision and order. So they affirmed it as to all parties and their counsel, meaning anyone who's a party to the case is gagged. That applies to the special counsel and who doesn't talk anyway, but also to all the defense attorneys and to the lawyers. The defendants. So all parties and their counsel, so Trump and his lawyers, and making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their participation in the proceeding. It's also affirmed about prohibiting all parties and counsel from making or directing others to make public statements about one, counsel in the case other than the special counsel, meaning Trump can still talk about Jack Smith, and two, members of the court staff and the counsel staffs, meaning he cannot do that, and family members of counsel or staff members. So essentially what she's doing is she's affirming that it's okay that she narrowed it down to those groups of people, right? That they're affirming that it was okay for Judge Chutkan to prohibit the parties and counsel from talking about the court staff and special counsel staff and family members, which I think makes sense. She said, if those statements are made with the intent to materially interfere with or cause others to materially interfere with counsel's or staff's work in the case, or that is highly likely to result, it's okay to, they affirmed that part of it. What they vacated, meaning what they said that Judge Chutkan, who actually limited her gag order from what Jack Smith wanted. So Jack Smith wanted this much gagged. Judge Chutkan narrowed it down to this much. And now the court of the DC Circuit has narrowed it slightly more so that it's just very narrowly tailored. And I'll explain why in a minute. But basically, they vacated the order if it covers speech beyond this. So, and we'll get to exactly what they mean in a minute. But the decision spelled out, and in great detail, actually, all the threats that Trump has made and the impact of the threats, how people explained how Trump calling them out ruined their lives, how it ruined it in so many ways. They got death threats, violence, need for police protection, how people doxed them by posting their addresses online. And she went, and the three judges went through it person by person, actually, and, would characterize the people and go through it person by person. And I thought that was important to do, and really reminds everyone how powerful this was, and that the people he singled out and the effects it had. They also talked about, like, he got arrested and then said this the next day, and then this happened. Like, they also put it in chronological kind of cause and effect order, which I thought was also quite powerful. And they said that, look, from day one, Judge Chutkan told the parties to take care with what they say about the proceedings in order to ensure the integrity of the proceedings. Both before and after the warning, they point out that Trump denigrated them. And the day after his first court appearance said, quote, "If you go after me, I'm coming after you," called Chutkan a hack, a fraud. And the day after that, she got called the N-word and death threats in her chambers. And he also went after Pence. Chutkan found that the speech posed a significant and immediate risk of witness intimidation to attorneys and staff, also that they would become targets. But she did say they could criticize the government generally. So the decision kind of reaffirms those positions, and also talked about how this was appropriately appealed midstream, which we call an interlocutory appeal, which means there's certain types of appeals where after a conviction, then the defendant appeals the conviction, and that's where all the issues get raised. But there's very few things that allow you to go midstream before it goes to trial. And there's clear law on what it has to be in order to do this. And this meets that standard. So does, by the way, the fact that he's the presidential immunity and double jeopardy claims that Trump is also appealing interlocutorily. So that also is happening midstream. But all the other things that he has lost will not. Those things will, he'll have to wait until after the conviction, if there is a conviction. So whether the order violates the Constitution is a question of law and subject to de novo review. And basically what that means is that really what this court has to do is interpret the law, obviously. And as a result, and because it's constitutional, this question, they get to review it de novo, meaning all over again, like as if they were the district court. And they will review the court's factual findings for clear error, and they'll only overturn the factual findings if they were left with definite and firm conviction that a mistake has been committed. And then they also said there's lots of things they could do. They could affirm the gag order decision, they can modify it, they can vacate it, they can set it aside, or they can reverse it. And what they did was they affirmed part of it and vacated part of it, or I guess modified it. Anyway, so they said because also these are two foundational constitutional values that intersect, that whatever they do, it must be narrowly tailored and no more broad than necessary to ensure a fair administration of justice. And the First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office, because this is the foundation of our democracy. And they gave a long recitation of the fundamentals of free speech, especially in the context of political speech. And that was sort of the backdrop. You know, they wanted to kind of set the stage, if you will, and explain how the rules of the road, the law, and the standards they're going to be applying. Personally, I still don't think that Trump, what he's saying is speech. I think it's conduct, because of the fact that he's doing it to get people to do these violent things and harass people and intimidate people. So I don't even think any of this analysis should apply. I think it's conduct. And if it's conduct, they can limit it. But I clearly am not on the DC circuit or in any sort of judicial interpretation capacity. I'm just a lawyer. Anyway, but that's my opinion. The decision goes on to talk about the importance of a right to a fair trial, because this is very important. This is what gives the court the right to gag Trump, frankly, and to gag his lawyers. And they went on and talked a lot about what the right to a fair trial means and having impartial jurors. And they cite to a case called Gentile. And they said, Mr. Trump's right to a fair trial does not give him the right to insist upon the opposite of that right. That is, a trial prejudiced in his favor. And they cite to a case called Singer versus United States, which is a Supreme Court case. And the public also has its own compelling interest in fair trials designed to end unjust judgments. And that comes from Article 2 of the Constitution's Take Care Clause. And they say, when a case involves extensive media and public interest, or when parties are trying their case in the media rather than the courtroom, court cannot sit back and wait for a carnival atmosphere to descend before acting. Courts have an ongoing obligation to ensure speech about a case doesn't divert the trial from the very purpose of the court system to adjudicate controversies in the calmness and solemnity in the courtroom according to legal procedures. So I really liked that framing as well, right? Like we have the whole function of a judge and a court is basically to ensure that everyone who has a right to trial goes to trial, and that it's fair, impartial, orderly, just, that there's no pressure, that it's not being influenced in any inappropriate way, et cetera. So that's actually the court's job. So it also talks about how it's think about it differently. The court is limited on what it can do to gag, for example, the press or the public, members of the public. But they can, and the law is very clear about this, they can regulate speech of trial participants. That's totally different. And that's all that's happening here. And they cited a case called Seattle Times versus Reinhart. And the Supreme Court has said neither prosecutors, counsel, accused, or witnesses, or court staff, or enforcement officers should be permitted to frustrate the court's function, citing Shepard, Gentile, and a few other cases. And a condition of this is another part I liked. A condition of Trump's release was not to speak to any witnesses except through counsel or in the presence of counsel, and Trump agreed. And so if he's not allowed to speak with them directly about the case, why is he allowed to use his megaphone, meaning his Truth Social account with his millions of followers, to talk to them? Because that's what he's doing. Now, the court considered 3 questions. Is the order justified by a sufficiently serious risk of prejudice to an ongoing judicial proceeding? Number 2, is this the less restrictive alternative to address the risk? And number 3, is the order narrowly tailored, including does it effectively address the potential prejudice? And they held that the district court, so they held yes 1 and 2, no for 3. It wasn't narrowly tailored. So we hold that the district court has the authority to restrain those aspects of Mr. Trump's speech that present a significant and imminent risk to the fair and orderly administration of justice, and that no least restrictive means or alternatives would adequately address that risk. We also hold that the district court's order was not narrowly tailored, and we modify its scope to bring it within constitutional bounds. Then there's a discussion, because if you remember, we talked about this on several legal AFs and hot takes, the whole question of what standard applies here. Is it that there's a substantial likelihood of material prejudice to the integrity of the proceedings, as Gentile says, or as Trump argued, is it that there's a clear and present danger to the trial process laid out in the landmark Communications versus Virginia case? And the court said, look, courts can do more than just wag their finger at a defendant and tell them not to do whatever the law already forbids. And Trump's version of the clear and present danger test has no legal mooring. And a clear and present danger test is for outsiders. It's not for parties to the proceedings. And the record before the district court and its factual findings demonstrate that some of the Trump's speech poses a significant and imminent threat to the fair and orderly adjudication of the criminal proceeding against him. The court then goes on to meticulously go through all the threats, like I said, and shows that he knows his words have real world consequences, like he said on Caitlin Collins on CNN when he said, "My followers listen to me like no one else." Mr. Trump's documented pattern of speech and its demonstrated real-time, real-world consequences pose a significant and imminent threat to the functioning of the criminal trial process in 2 respects. Number 1, he knows that they are witnesses and that he could impact their willingness to participate in the process, which would frustrate the trial court's essential truth-finding function. They also show there's no question he isn't allowed to speak directly to a witness about a case. So why should he be allowed to do it on social media? Like I said before, knowing that this message will get to the person. And number two, certain speech about counsel and staff working on the case poses a significant and imminent risk of impeding the adjudication of the case. Courts have a legitimate interest in protecting the judicial system from outside pressures. I love this quote. Ready? Given the record in this case, the court had a duty to act proactively to prevent the creation of an atmosphere of fear or intimidation aimed at preventing trial participations and staff from performing their functions within the trial process. And they shoot down Trump's three objections: that there's no harm, that there's no obstruction to witnesses or the judicial process, etc. And he says, I'm not responsible for what other people do. And they said, you know what? They called that the heckler's veto, and they said, oh, clearly Mr. Trump misunderstands the heckler's veto. That only prohibits restricting speech if it might incite. But here we have a demonstrated record that he knows his followers will listen to him. It's just great. So they also say you don't get one free bite to derail the process and then rule. You get to prevent it. And they ruled there's another fundamental constitutional interest at stake here. The existence of a political campaign or political speech does not alter the court's historical commitment or obligation to ensure the fair administration of justice in criminal cases. A trial participant's engagement in political speech cannot degrade or diminish that essential judicial function. Mr. Trump acknowledges as much by accepting his pretrial release condition that he cannot speak to witnesses about the case, political or otherwise, and he cannot evade the legitimate limitation by dressing up messages to witnesses in political speech garb. Sometimes I love the way judges talk in their decisions. So they found that there was no less speech restrictive alternative that could protect against this. Says that Chutkan tried when she cautioned the parties to voluntarily watch what they said, and that didn't work. They said, look, we can't really move it to another location. That could, given Trump's reach and delaying the trial, this is great because this shows they realize that they have to go forward and expedite things. And this is important for the presidential immunity issue that's also going up to them, because they say delaying the trial date until after the election, as Mr. Trump proposes, would be counterproductive, create perverse incentives, and unreasonably burden the judicial process. Allowing prejudicial statements to go unchecked for even longer pretrial period would simply compound the problem. So I thought that was great. And they cite to Caitlin Collins' town hall where he says he listens to them like no one else. I bet she loves that she cited in a DC court, what she did is cited in there. So then my other favorite line is, in this case, the general election is almost a year away and will long post-date the trial in this case. The reason I love that is because it shows that they have absolutely no plan on allowing him to delay. So hopefully the Supreme Court catches wind of this and doesn't do it either. And they push it too, but we never know what they'll do. The one thing they didn't like was they didn't like Chutkan's use of the word target, because she said he's not allowed to target witnesses or trial personnel. They said that that's just too broad. It captures some constitutionally protected speech. Like, what if he wants to say that a potential witness is a liar, or that Smith is a Trump hater, or that the courthouse staff has been terrific and helpful, So they said it's too broad. He should be allowed to say those things. So they said instead it just prohibits speech on comments that speak to or about those persons' potential participation in the investigation or this criminal proceeding. So they give two examples. One would be they like a high profile person versus not. So for example, a high profile person who's also a witness, that's one thing, like Bill Barr, who went on TV and Trump posted about him, calling him slow-thinking, lethargic, had no courage or stamina, and he refused to fight election fraud. These statements and criticisms, they said, don't have anything to do with the case. I'm not sure I agree with that, but that's what they said. But then talk about a poll worker, but for this case, you wouldn't know their name. Proceed at your own peril. And they also said Meadows, for example, after news broke that he was cooperating, Trump called him a weakling, a coward, who would make up a really horrible stuff in exchange for immunity by a deranged prosecutor. And they said, look, proceed at your own peril with that because the timing and words are clearly about Meadows as a potential witness. So similarly, he can criticize the justice system all he wants, but people working on this case can impact, but the people working on this case can impact the case. So that's off limits. So, but the one thing I disagreed with is that it's okay to go after prosecutors and judges because they said, look, just because they have they said, what they said was prosecutors have so much power, they can take away someone's liberty, same as courts and judges. I disagree with that. I don't think it's okay to threaten or cause death threats. These are public servants, and I don't think it's okay for Trump to be able to cause that to happen. Either he's a danger or he's not. Anyway, they sign off by saying a beautiful quote that says, "We do not allow such an order lightly. Mr. Trump is a former president and current candidate for the presidency, and there's a strong public interest in what he has to say, but Mr. Trump is also an indicted criminal defendant, and he must stand trial in a courtroom under the same procedures that govern all other criminal defendants. That is what the rule of law means. So ordered." Great decision, and Trump is gagged. I'm Karen Friedman Agnifilo from Legal AF. Join me and my co-hosts every Wednesday and Saturday.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.